From the minutes, item number 1.
Mr. Deb,
Lordship, yes.
before you start, we have 2 or 3 questions,
Lordship.
and then you can go on uninterrupted.
Absolutely.
First is, what was the age of the victim?
Lordship. Lordship, 21 to 22.
21.
Lordship.
He was a student of St. Anthony's College.
Lordship, yes. Second year mass communication.
A student of second year
Mass communication.
mass communication or Cations? Cations, St. Anthony's. Now, when was the missing complaint lodged? On 19th?
Lordship, yes. 19th, Lordship. 19th February 2006.
2006.
Lordship, yes.
When was Bernard arrested?
Lordship, Bernard was arrested, formally arrested on 20th, but he was in custody from 19th morning.
19th?
Morning.
How could he be in 19th morning if he went searching on 19th whole day?
Lordship, that comes from his 164, Lordship. I'll just give Lordship the exact time.
His statement as to his arrest is of no
9 a.m. Lordship.
9?
9 a.m. of 19th.
9 a.m. of 19th he says. Is there any other thing from which you get 9 a.m. on 19th?
From the depositions of the other evidences also, that what happened, Lordship, is from 19th morning, he was not arrested per se. He was...
Where is the memo of arrest?
Lordship, memo of arrest is of 20th.
But we have to go by that. You have not questioned it.
No, because it was never from what he was not arrested on 19th. He was in the morning. He was with the police, with the search team and all.
Yes, so we are talking of arrest. We are not talking of anything else. Because he went around with everybody else. How could he be arrested?
Lordship, yes.
He was arrested on 20th.
Lordship, yes. And on the 19th night, he was in police custody.
How?
He was in the police station. He spent the night in the police station.
How do we know that? If the memo of arrest does not show that, how do you say that? Where is the evidence for that?
Lordship, that is at page, if Lordship may kindly see the 164 as recorded by the
164 is his statement.
That is from where it comes, Lordship.
From nowhere else.
And the judgment as well. There are evidences which have been recorded in the judgment as well that on 19th.
Show us that he was arrested on 19th.
Lordship, yes.
Not from the judgment. Show us evidence. The judge has gone all over the place. Absolutely nonsense.
Lordship, yes.
Where do we find the memorandum of arrest?
If Lordship, memo of arrest is at page 48 onwards. Lordship.
48.
Lordship may kindly come to page 53.
Just a second. 48 is
It
memo
starts
of arrest.
from the Bernard's arrest memo is on page 53.
Bernard is 48, huh?
53, Lordship. 53.
No, Bernard is 48. We can see at 48.
48 also. Lordship. No, 48, the one at 48, Lordship, is the warrant of arrest.
Yes.
The memo of arrest is at page 53, Lordship.
53.
Yes.
Yes.
Lordship will see on top, my lord, date 20th 2, 2006, 9 a.m.
Where are you?
At page 53, my lord, the
Where do you find that?
lordship, 4 lines from the top, lordship. Date, it is
Yes,
written
9
date.
a.m. 22.
Yes. GDE number 593.
And warrant of arrest is also issued on 20th.
Lordship, warrant of arrest, my lord, is warrant of arrest is issued on, appears to have been issued on 27th January, my lord.
No, 2012.
Some,
That is the evidence at the trial. That's the exhibit at the trial.
yes, lord. That is not, at that point of time, no warrant was issued.
Stands charges offence, arrest the accused, proceed before me, honor before 20th February 2012.
Lordship, yes.
Anyway, but the memo of arrest shows 9 a.m.
Of 20th.
Memo of arrest, page 53. From where else do you say that he was in custody on 19th?
Lordship, may kindly come to page 320, my lord.
320.
This is deposition of PW 33, the IO.
Yes.
Page 320, lordship, the second paragraph. On 19th February 2006, on receipt of the FIR, so and so. Just skipping a few lines, my lord. The line.
Come to the over the page. One person named Bernard Lindo was interrogated on 20th February.
No, interrogated, and on 20th he was placed under arrest, lord.
Then, so 20th he was arrested.
20th he was arrested, but he was interrogated on 19th.
Where did he say?
The lordship, the paragraph says on 19th, so and so, so and so. Then I started the investigation.
No, that it does not refer to date of thing interrogation.
I then started the investigation. In course of my investigation, one person named.
That's all right. Anywhere else to show he was arrested on 19th?
That is in the 164, my lord.
164 is erroneous.
Apart from that, it's not.
164 is erroneous. Yes. Now you proceed.
May it please, your lordship. Lordships, if I may so submit.
Lord Bernard.
Lordship.
Yes.
My lord, the case of the prosecution at the trial court, lordship.
Yes.
And I'll try to, my lord, satisfy your lordships that the judgment which was passed can stand in its own legs. If I may
Just now.
refer to the judgment itself.
Read it
lordship.
just now. Absolutely.
Some parts, of course, lordship. Lordship, if I may submit, lordship.
You know, there are two or three things we'll tell you why. It's on very flimsy grounds that the testimony of the judicial magistrate and the confession, there's no extraction.
Lordship.
Number one. Despite there being no extraction, just because the judicial magistrate had conducted the inquest
Lordship.
and had written a wrong date, it was discarded.
Those were the
It can't be done so lightly.
Lordship.
And that is the main place.
Lordship, yes.
The others, we are not impressed with. Their investigation, we are not impressed with. It's only this, your statement, as we have said from the beginning. Yes, carry on.
Lordship, what I was trying to impress upon your lordship is that in the trial court, lordship, the prosecution placed its case on 7 points, my lord, which would determine my guilt. The first point, lordship, was the last seen theory. The last seen theory was, my lord, found to be not proved.
Last seen theory is a red herring.
It was not proved, lordship. In fact, apart from anything else, there was
Not necessary. Last seen theory is not necessary.
The second issue, my lord, which the prosecution urged before the trial court, was that the death of the deceased was due to strangulation. That was, my lord, duly proved. There's no.
Yes, there's no proof. There is only one. The doctor said It may be hanging, it may be strangulation,
Lordship, yes.
but the hired bones were broken on both sides, and there was no frothing or things like that, which are telltale signs of strangulation. So maybe, may not be.
Lordship, yes.
But we are convinced murder weapon was not found.
Lordship, yes. So, Lordship, the trial court also has said that the death has been caused due to strangulation. The trial court has given the finding, Lordship. The second point, my lord, which was urged by the prosecution, was the recovery of the body, Lordship.
So we'll go point by point. You're going on 7 points.
Lordship.
First point, last scene.
Theory, Lordship. And these were the points.
Trial court rejected.
Lordship.
Second point, strangulation.
Yes.
Trial court accepted. Third point,
my lord, which the prosecution has, was the recovery of the dead body.
Recovery of dead body.
Lordship, the recovery of the dead body, Lordship, the trial court has rejected the argument.
Has?
Rejected the argument
We also accept
in view
that.
of section 25.
We accept that.
Lordship.
There is no discovery at the instance of either Bernard or Alpha. Rejected discovery, correct?
Similarly, Lordship, the recovery of the rope.
Recovery of rope rejected, rightly rejected.
Thereafter, my lord,
5.
Lordship, was the forensic evidence. Forensic evidence in connection with the rope being used as a murder weapon. That was, my lord, rejected in view of the FSL finding that there was no link.
Forensic report. Rope rejected.
Rope has been rejected, my lord. Nothing to show that.
Very good.
Now, my lord, the next point, Lordship, was the recovery of the incriminating articles belonging to the deceased. Those articles would mean, my lord, the mobile phone, laptop, and so on. So all of them have been also
incriminating evidence regarding articles of deceased.
not proved.
Rejected. Yes. 7.
And the last point which the prosecution urged, my lord, was the confession statement. If I may take your lordships to the findings of the learned judge in view of...
Rubbish.
And what was the argument?
Come to page 540.
Lordship. Lordship, yes. 540.
Place the entirety so as not to do disservice to the judge.
Okay.
But while you place it, see how much you are convinced by it.
Lordship, please. Lordship, the relevant portion, my lord, in my humble submission would start from page 542 at paragraph 94.
Yes. And that by itself is wrong.
Before deciding whether the statement recorded by the magistrate is voluntary or not, it is firstly observed that the confessional statement of the accused persons were recorded after the discovery of the death of the victim, or dead body of the victim, and the rope in bracket murder weapon, and the magistrate who was present at the time of exhumation of the dead body had also recorded the confessional statement of the accused persons, which created doubt at the very instance.
Does not follow.
Lordship has already mentioned, my lord, that because of the
Which created doubt does not follow.
Lordship. Thereafter, my lord, the learned trial court says, as per the prosecution, they have also submitted that both the accused have voluntarily given their it should have been confessional statements before the magistrate, but before accepting the same, it has to clear the desk as to whether the confession was made voluntarily as per provision provided under 164 CRPC, as also section 30 of Evidence Act. In this regard, PW 32 is the magistrate, my lord, in her statement, has stated that she had recorded the confessional statement of the accused persons, and also stated that the accused were produced before her, and on explaining the requirement as provided under section 164 CRPC, she had recorded the confessional statements of the accused persons and had proven the same as Exhibit 19 and 20 respectively.
Now, pause here for a moment.
Lordship.
she had recorded the confessional statement and had also stated the accused were produced before her, and on explaining the requirement as provided under 164, she had recorded the statement.
Lordship, yes.
That's her statement.
Lordship.
Now, see what sanctity has to be given to her statement and how frivolously the trial court disregards that. Once this is said, come to section 80
Lordship.
of the Evidence Act. What does it say?
Lordship, it basically says that the statement recorded by the magistrate in the judicial proceeding has a presumption as to its genuinity.
No, sir. That's why we are saying.
Read it, Lordship.
Read section 80. You don't have the Evidence Act.
No, it's not marked, Lordship.
Take out your phone on top. You're using it as part of your submission. There's no point hiding it.
Presumption, Lordship. Presumption as to documents produced as records of evidence.
Yes, read it.
Whenever any document is produced before any court, purporting to be a record or memorandum of the evidence, or of any part of the evidence given by a witness in a judicial proceeding, or before any officer authorized by law to take such evidence, or to be statement or confession by any prisoner or accused person taken in accordance with law, and purporting to be signed by any judge or magistrate, or by any such officer as aforesaid, the court shall presume.
But court shall presume.
Lordship.
Now come to section 4 of the Evidence Act.
Lordship. Section 4, my lord, may presume. Whenever it is provided by this act that the court may presume a fact, it may either regard such fact as proved, unless and until it is disproved, or may call for proof of it.
Shall presume.
Shall presume, whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved, unless and until it is disproved.
Where is this disproved?
It is not there, my lord. I fairly submit, Lord.
Now, if it is, we won't attribute the acceptance of this argument to you.
Lordship.
We won't, but we thank you for not being, wasteful. That is the duty that she has to. It has to be disproved.
It has to be disproved.
Until such time that you disprove it. Now, in law, there is no requirement of the magistrate to be produced.
Lordship, yes.
But she actually came. You did not, in the cross-examination, disprove it. We are on disprove.
Lordship, yes.
You may have said something about how bright it was on a Sunday, how rainy it was on a Tuesday, but you did not disprove it. That's all that we are concerned with in law.
Lordship.
Secondly, sir, most importantly, these documents were made available to you under 207.
Lordship.
The trial commenced when?
Six itself, my lord.
19 June 2006.
Lordship, 19 June 2006, my lord.
19 June 2006, as early as that.
Lordship.
And what is the date of the judgment?
26/3/19.
26th March 2019, Lordship.
26 March 2019.
19.
And when was the 313th statement recorded?
March 2011.
14th March, Lordship.
14 March?
2011.
That's at page
386, my lord.
14th March 2011. Now, it's a cardinal principle that when you want to retract any statement attributed to you, you ought to furnish an explanation and it ought to be done at the earliest opportunity.
Absolutely, Lordship.
Nothing attempted to be done. The only thing is your allegations at the 313 stage. Forensically, what we have to do is take your allegations and see whether it disproves or not. If it does not, it does not.
Lordship.
That's the test.
Lordship.
And this is the crux of the matter.
Lordship, yes.
The trial court missed the wood for the trees. There are many anomalies. PW 18, PW 25, PW 20, and that IO, everything. There are a whole lot of anomalies. Whether it was Biplop's phone was missing. But what comes through, what stands ultimately, your confession, the PCO bills, and the fact that the PCO owner, according to one of the witnesses, PW1 probably,
David, yes. According to David, Lordship.
according to
PW 17 Lordship.
Yes.
17 is
David.
According to David.
Roger.
Yes. According to PW 17, David, he said that
I'm sorry, PW7 is Roger, Lordship.
is Roger. That,
Roger something.
Roger, yes.
Roger Lordship, yes.
yes. What's the difference between a David and a Roger? Yes. Except that David met Goliath, Roger did not.
Lordship, yes. He says that the PCO was told by Bernard not to disclose.
It's a weak piece of evidence. But it's at least somewhat connects. It's very weak. Can't be convicted only on that. But, we are looking at straws over here. And that is something of a straw over here in the context of
If I
the
may
larger picture.
submit, my lord, as regards the PCO phone call which was made to Nirvika by Biplop, my lord. Lordship, what comes out from Nirvika's deposition is that in the morning of 18th, Biplop had met her and told her that he will not be in a position to get his laptop on that day because he'll be going out in the evening with Bernard. And
He had said we're going out with Bernard.
she said it, my lord. And then, Lordship, she eventually received a phone call at about 8:30 p.m. from the PCO at Mauro, Lordship. If my humble submission, my lord, is that if Biplop at the time when he made the call to Nirvika was with Bernard and Bonnie, what stopped him, my lord, to not say that I was still with Bernard?
No, what would prompt him to say? Or what according to Nirvika did Biplop tell her?
She said that Biplop told her that
Let's come to that.
Lordship, Nirvika's evidence, Lordship, will be at page 137 onwards. And 145 is the type copy, Lordship. 145.
Thank you.
And there is also a 164 of Nirvika as well.
No contradiction.
No contradiction. Page 145, my lord, in the third paragraph. On 18/2/2006, Lordship has it.
Yes.
Lordship. On 18/2/2006, the laptop computer of late Biplop Das was lying with me and he was supposed to come and take it. However, at around 8:30 p.m., I received a telephone call from late Biplop informing me that he was unable to come that evening but would come and collect the laptop the next day. He also told me on the phone that he was somewhere in Maukhar with two friends from Siliguri whose names I do not recollect now. And in her 164, she mentions one
Sumit.
as Sumit. Lordship. And this is the same statement which Bernard has told Purkayastha, Lordship. that Biplab had left with two of his friends from Siliguri. So if my humble submission is, my lord, that if Nirvika was informed by Biplab in the morning that he would be going out with Bernard, what if at 8:30, lordship, when the phone call was made from the PCO, if Bernard was still there, and since the PCO owner also says that on 18th Bernard came and told him not to disclose his identity, he does not talk about Biplab making the phone call.
No, that not to disclose identity was on 19th.
18th, lordship, on the same day.
Same day.
Meet 18th.
Very well.
The PCO owner says, my lord, that on 18th, 3 persons came, and on 18th again, the same 3 persons came and told him not to disclose the identity of one of the 3. That would be Bernard. So if that was the case, my lord, at 8:30 p.m. on 18th.
That is not the evidence of the PCO. That is Roger's evidence as to PCO.
No, in the PCO owners also says that.
All right. Just show that and come back to Nirvika, please.
Where is that?
PW22.
Lordship, PW22, my lord, at page 276 onwards. And the type copies are 278, lordship.
I told you on 19th.
But it doesn't make sense, my lord, in my hub. On 18/2/2006, some persons came to use the PCO, and on the following day, on 19, the same persons. So, admittedly, my lord, the PCO call was made by Biplab. On 19th, he could not have come in.
Huh?
It could not have been the same persons.
May not be same persons. By and large, you have to take it as, if there were 3, 2 of them if came, same persons, more or less.
And then he says, came and asking me to withhold our identity for using the PCO on further inquiry by me as the PCO owner. They said that the matter is in connection. Whereas, my lord, the Roger says that at the time when he was told
Let us see Roger.
by the PCO owner,
Let us see
Bernard
Roger.
was in the vehicle, lordship. Roger PW17, my lord, at page 219. And the right is at 235, lordship. 235, my lord.
35.
The relevant part would be at page 237, my lord, with regard to this.
Yes.
237, my lord. 5 lines from the top.
Initially, Bernard was reluctant and to accompany, but eventually agreed.
To accompany us in search of Biplab Das. Then, along with Bernard and our team, we left again to PCO at Mola in the same tourist taxi. We requested Bernard to inquire from the owner of the PCO if he could supply us any information of the missing of Biplab Das. Then the owner of the PCO called me in the corner of the PCO and informed me that Bernard had come on 18/2/2006 in the evening and told that he told the owner of the PCO should not tell anybody or disclose that Bernard came to his PCO on the night of 18/2/2006. At the time when we were in the PCO complex at Molai, Sri Bernard was sitting in the tourist taxi. After the said meeting, we escorted Bernard's residence and dispersed us. And
Yes. Now you were on Nirvika and you were making your arguments on Nirvika.
Lordship. So I was trying to submit, my lord, that on 18th when the phone call was made, if Biplab was there with Bernard and Bonnie or whoever, my lord, why would he himself lie to Nirvika that
Why?
he was
Where is he lying? So which part is he lying?
He says, my lord, that she says that Biplab told her that he was with some friends from Siliguri, whereas on the earlier occasion on the same date, as per her deposition, Biplab clearly said that he would be going out with Bernard. So he could have simply said the same thing, that I am still out with Bernard, or
Recollection, friends with Siliguri, friends from Siliguri, doesn't matter.
and that was the same thing which Bernard also told Purkayastha, that after a certain point of time in the evening, Biplab left with some friends from Siliguri.
And what about the three-wheeler driver?
Three-wheeler driver, my lord, firstly he starts by saying 19th. So on 19th, as per the prosecution's case, it could not have happened.
Could not have happened.
And secondly, he could not identify the deceased.
He could not identify.
The deceased.
He said one non-tribal.
One non-tribal, few Khasi men, all drunk. They came, they embarked my auto at Polo. They took a lift till Mauro, and then he proceeded and they proceeded. But on 19th, he says 19th.
Yes, 19th. He said 19th. But if you disregard the date, that again, imperfect recollection, disregard the date, then it fits well if it happens on 18th.
Lordship, yes. But in cross also, that was reaffirmed that it was on 19th.
Let us see how it was reaffirmed.
Again, my lord.
Auto driver.
Auto driver. Page 178, my lord. And the typed version is at 185, lordship.
Yes, give us the type version. Don't make us correct every type.
185, my lord. DW12 at page 185. On 19/2, I was at Polo in an auto rickshaw bearing number so and so at about 9 p.m. I was a driver of the said auto rickshaw. On that day, that is 19/2006, there were 6 passengers who took lift on my auto from Polo and proceeding towards Mauro. 1 passenger was non-tribal and the rest 5 passengers were all Hasi. 3 passengers of my auto got down halfway at a place called Lat Sanker Maulai Mauro, and the other passengers got down at a place before reaching FCI at Maulai GS Road, Shillong. After leaving the passengers to their destination, I returned with my auto to Polo. Police party from Sadar PS have recorded my statement, and my statement was recorded at so and so.
Now, please come to page 186.
Not sure.
Please come to cross-examination by Bernard. Third one.
Not sure.
It is not a fact that there are no persons who travel with me on the aforesaid date of 18th.
Not sure.
It is not a fact that 2 accused persons did not fly in my auto on 19th.
Contradiction.
So that's how, these people make mistake with dates.
Not sure.
The essence is that he carried some persons. And he thinks it's on 19th, may have been 18th also.
Not sure.
Lordship, just to assess the court.
Let us see what he says to Bonnie.
Nothing much with regard to the date, except that it is not a fact that on the date of occurrence, the accused and the other non-tribal did not board my auto rickshaw.
So he identifies accused, Bonnie.
He identifies the accused. Both the accused, he doesn't identify the...
He accused, both Bernard and Bonnie he accused. He identifies.
If I may clarify, my lord, on Bonnie's
Thank you. Yes.
If Lordship kindly comes to 186 first paragraph, my lord.
186 first paragraph. I know the accused who are in my auto and the accused are present in the dock today. The two accused along with another passenger were all insufferable. And for Bonnie, it says, the accused Bonnie is known to me from my childhood and we used to reside together in the same compound.
It appears he has
Where is
identified.
Exhibit D1?
Not sure.
Page, that's what Lordship, I was assisting the court, Your Lordship. Page 479,
Page 479.
volume 2. Your Lordship.
Yes.
I was just trying to assist the court on this.
In fact, this would clear the air, my lord. I would also fairly submit.
Just a second.
This is the 164, 479.
479. And the type copy would be at
479 is the 479.
type copy is at 479.
The date is clarified.
On 18th February,
At about 8 to 8:15.
I was at Polo, just at Polo Bazaar. During that time, one
Bernard Power, Bonnie
whom I
Power.
know for the last 10 years came and asked me to take them tomorrow. During these two were with one non-tribal boy. The non-tribal boy was their friend. I do not know. On reaching junction leading to Shankar Nursing Home, also alighted. They paid me 15 and thereafter.
So this was very clear, my lord. But he contradicted himself with the evidence, and the learned trial
The
court.
art of advocacy is not to hide,
Lordship is.
is to present and then argue.
Lordship is. And the learned trial court has not.
So you are going on
Seen
mix-up
this.
of dates. If one goes by the 164 statement,
There is no mix-up.
There is no
There
mix-up
is no
by
mix-up.
of date.
I was only trying to say because the learned trial court has
That's
taken
not-
the date of the evidence.
That's not, you're far too young to do this.
No, it is not my intention to mislead. This is very clear, Lordship.
You know, you should bring it out and then tell the court if you have an argument.
Lordship.
Yes.
No, I was not
We
for,
rely on you also.
no, not for a moment. I was coming to this, my lord. Fairly, I would have pointed it out.
If we now had not asked for 479, we doubt if you would have come there.
No, no, in fact, I mentioned also
Anyway,
that
all right,
there's a
we'll
one.
give you the benefit of the doubt. Yes.
So the learned trial court has relied on the evidence date given by him in the evidence and rejected the argument of the PW auto driver, saying that it was on 19th, and on 19th it could not have been possible.
Exactly.
Lordship,
Anything else?
here, my lord, of course, after my on a fair submission I'm giving, my lord, without prejudice to my defense, the 164, my lord, appears to have been recorded in accordance with law, and nothing as such was done.
Very good. Now let us think a bit. The general principle is you don't found conviction on 164. It's another bit of evidence. Why not? Because there will be other material from which. Now over here, there are some material. There are material from the PCO, material from the PCO owner, material from the auto driver, and the fact that your statements are there, that you were together with him. When do we discredit a statement voluntarily made? If the court feels that the maker of the statement is attempting to shield somebody, a mother may come and say, I have committed the crime to save her son. If the court is of the perception that the maker of the statement has been induced or by coercion or by threat, does not happen to be so. And really, the statement over here cannot be said to be a confession if confession is admission to a crime. Neither of them says they are charged with what? You are charged with 364A,
30.
302, 201, read with 34.
Lordship.
364A, there is nothing in the confession which amounts to 364A.
No, Lordship.
They have also not been able to make out a 364A case. Next is 201, nothing in the statement really about concealment of evidence. But the moment 302 is there, and the moment it is dug out, irrespective of who led to the discovery, 201 comes in. You don't have to go any other way. Now, as to 302, neither Bernard nor Bonnie says, I killed him. Confession is, I killed him. Confession is not, he killed him.
Not space.
Confession has to be, I killed him.
Yes.
Bernard does not say so, Bonnie does not say so.
Not space.
But it is an admission of being present with the victim at or about the time of the victim's death.
Not space.
Both of you say so. After that, we've indicated.
The 106 and everything, Lordship.
After that, we've indicated.
My Lordship, which is why I was fairly submitting. In fact, on the last date, Lordship had given the points, my Lord. And as far as those points are concerned, my Lord, the section 80 and the 164 and how it is to be recorded, I fairly do not have much to argue. On the material, there is not much, Lordship. And the retraction, as far as a retraction is concerned, although there is a retraction, my Lord, the reasons for the retraction don't seem to be very...
No, you don't have to make that submission. We will not attribute to you. You stick to your retraction.
Lordship.
And then at the end of the day, we will decide whether that retraction. You don't have to.
So
you have made no concession. We will not record any concession.
So the learned trial court has gone into two things. One is, of course, the question answer form and that she had the knowledge of the case.
Does it affect?
That is one part, my lord. And the second thing, the learned trial court has also said that since there is no confession per se, and the statement cannot be used against the other in view of section 30.
No, she has gone completely wrong. Sometimes statements can be used against the co-accused also. But the general thing is, when two persons are accused, to ensure that the news does not come on to you, you shift the blame. That's when the court will disbelieve. Here we are not relying on Bernard's statement that he saw him tie the news. We are not relying on that.
The trial court has disbelieved the entire statement.
No, that cannot be. That's all.
So, one few submissions, my lord. Firstly, my lord, that this aspect of that 164 being the basis of my conviction was never urged per se by the prosecution at the trial stage. If lordship sees the arguments advanced,
neither it's for the court to see. It's not for the prosecution.
The prosecution never urged that.
Court to see.
And secondly, even now in the grounds of appeal, no ground, my lord, as regards the 164. They are on the last scene theory and the recovery. Those things, my lord, there is no ground of appeal that I should
ground. We will show you the ground.
Lordship, grounds of appeal, page 568 of volume 2.
Yes.
$568, Lordship.
Are these ransom calls admitted or proved?
No, my lord. Ransom calls were made on 19th from Guwahati, and the IO had even gone to Guwahati, found a certain PCO from where the phone call was actually made.
2 and 4 fairly cover it. They are omnibus grounds.
Of course, that is there, my lord. But if Lordship kindly sees...
Actually, in civil law, in memo of appeal, there is one ultimate ground for that: the judgment and order are otherwise bad in facts and in law, and are liable to be set aside. That covers everything.
Lordship. But for the sake of my submission,
That is not the thrust. You are absolutely right.
that
That is not the thrust.
Yes, neither in the trial stage
in
nor-
fact, the IO made a fool of himself completely in whatever he said.
only, my lord, what is falling now after the long days of hearing, those points, my lord, I fairly submit legally.
Thank you. Because at the end of the day, closure has to be given by court. And justice has to be done both to you and to the victim or the family of the victim.
Absolutely.
Any law or anything else?
Well, laws, most of them, my friend,
Yes,
is
we've
already
noticed that.
on the retracted
Very good.
confession
Yes.
in 164.
Yes, anything else for you, madam? You wanted to say?
Only,
No, Lordship, that was just a query which had fallen from your Lordship. So I was just clarifying.
only one, with regards to why the question answer form was so substantial as far as the trial court, my lord, it appears that they have relied on a judgment reported in 1981. It's a one-page judgment which says, my lord, that the 164 confession recorded by the judicial magistrate in question answer form has to be rejected.
Has to be?
Rejected.
Who has cited that?
It was cited in the judgment, and probably the learned court has referred to that. But that is a one-page judgment. What is the
That
fact is not very clear.
There's nothing which shows that. As long as you make him aware and look at the questions, come to them, look at the questions. The questions are just to elicit response. If you come to the nature of them, come to page 23.
23.
23.
Not sure. Yes.
This is Bonnie.
Not sure.
Do you know that you've been produced for recording your confessional statement in the instant case?
Yes.
Yes. Clear indication of mind.
Not sure.
What do you know about the case? Instead of this, the magistrate could have said, do you want to say something? So what do you know about the case? Nothing. There's no
Leading question.
leading. Well, it does not apply that principle of leading question, but there is nothing, no, it's not inquisitorial. It would have been wrong if it had been inquisitorial,
Not sure.
not leading question.
Not sure.
Leading question happens when you get your witness to say something that you want to argue.
Not sure. Sorry.
This is not a,
Not sure.
if it had been inquisitorial, what did you do?
Not
How did you kill? How did you deal with the body?
Not sure.
What did you do in the graveyard? Because from the graveyard, we reach the graveyard. What did you do in the graveyard?
Not sure.
And then he blurts out. Then 9, what more do you want to say? Nothing, no, nothing inquisitorial. Then you drop the mobile. Where have you kept the mobile? Probably not the right question. But he gives an answer to this. And the mobile thing is because mobile was in one of the answers.
Not sure.
This is not a proper question, the mobile. To an extent it is inquisitorial, but still, even if we disregard it, does not matter. Not been proved.
Not sure. Yes.
And so far as Bernard is concerned, let us see the same thing.
Not sure. From
And tell me something, Mr. Dev.
not sure.
Because there is a mistaken date in Bonnie's statement, Bernard's confession has to be thrown out.
No effect. It has no effect. Which is why I said, Manoj, after going through the everything, there is nothing much to.
See, again come to 37.
37, not sure.
Says your confession statement, so makes him aware. Confession statement, are you aware? He says yes.
Not sure.
Says Last question. What more do you want to say? Nothing. Only difficulty arises whether one has to go strictly by the postmortem doctor's assessment, 48 hours. The examination was conducted on 22nd.
Lordship.
Was conducted on 22nd.
22nd.
Body was exhumed on 21st. Examination conducted on 22nd. Whether 48 hours should restrict it to 20th and therefore rule everything out.
Lordship.
Now, by 20th, let us see how implausible that would be. By 19th, everyone in the world knew.
Lordship.
There was a manhunt on. These people were in the net.
Lordship.
At least by 20th, he was also in the net.
Absolutely.
There is no theory that has been propounded for the murder taking place on 20th.
The only thing, my lord, is that the ransom call which was made to the father of the deceased on 19th, 2 calls were made, my lord, after a certain duration of points. Initially, a ransom demand was made for about 80 lakhs, and the second call, it was made reduced to up to 50 lakhs.
But they were not proved.
They were not proved, but
Because that in Guwahati, that fancy bazaar or whatever, not Polton Bazaar.
Polton Bazaar.
Polton Bazaar. They were not proved. Those were not seized.
it was seized, but it was never, the PC owner was never called to prove it. But otherwise, the paper mark is there. And those paper marks, the records of the PCO showed that, in fact, someone had called from that particular PCO in Guwahati
To that number.
to the number of the
Father.
deceased's father on 19th, saying that, my lord, that the son is with them, still alive, and
It's not inconsistent with you kill or accidentally kill and you can still, it does not prove anything either way.
but from Guwahati. That is the
But from Guwahati, yes.
from Guwahati, my lord. So coupled with the fact that Nirvika was told that Biplab was out.
Siliguri friends.
Siliguri friends. That is what Purkayastha also says. And
We have to look at the broader picture. Thank you. Anything else, Mr. Khan?
Nothing much, Lordship, except I don't know.
What is that?
Lordship, we had relied on, I hope the copy is with the court. Give it Marak judgment, Your Lordship.
Sorry?
This is a granite Marak. Judgment we had relied, Lordship.
Unreported judgment.
Lordship, yes. This
Yes.
relevant paragraph is at page 27. We've given a copy.
Do we have copies of all the judgments that they've given? Where are the judgments?
And Lordship would like to give Madhi Ganga's copy also, Lordship. We have got extra copy.
Not necessarily. We have not formally cited it. We are also not
Lordship.
formally referring it.
The only thing is Granite Marak's para 27, Your Lordship.
Para 27.
Para 27.
We have a copy.
Lordship, yes. This,
We have copies.
this para 27 addresses the larger issue that has been raised by the court.
Yeah.
That's all.
Today is the 25th.
only one more, just
Yes,
a few points,
yes.
Lordship. Firstly, my lord, as Lordship has seen, motive was never proved. So that is also
The motive was not.
one point, my lord. 364A was not established at all. 302, my lord, it's here and there.
302, 201 done.
Lordship. But what I was trying to submit, my lord, is that 34
It
charges
was
were
open
never
to you.
framed.
It was open to you to take a plea of 304, Part B.
For intoxication. I understand, Lordship.
It was open to you, but that would have meant to confession of a sort.
Yes, and then the burden would be
Then you would have had to, and we would have gladly given you 304 Part 2. We would have gladly given you,
Lordship.
because we don't find that meeting of mind to kill,
Lordship. No intention was there.
no meeting of mind to kill, but actually killed.
Lordship. That was not the
No
defense
meeting of
that
mind
was-
to kill. So to that extent, we don't find it.
Lordship. And 34
So the
charges.
moment you would have said 304 Part B, we would have gone for it.
But since that was never the case at
That
this
was not
stage,
the case. That was not the case. You can't make it out now.
Lordship. And only one more point, my lord. 34 charges were never framed.
No. Clearly done.
No,
Clearly done. Look at Justice Dingo's reading out the statement. Page 17. Page 11, not so. Page 11.
11, Lordship. Firstly,
You. Who are the you?
both the accused, Lordship.
Both. 34 does not entail a sentence.
Lordship, yes.
364 entails a sentence, he pronounced 364. 201 entails a sentence, he pronounced 201. 302 entails a sentence, he pronounced 302. But the moment he says you and names the two of you together, 34 is done. And look at the trial court judgment. Trial court also read 34 to be there. Look at the second page of trial court judgment at page 501 or 502. Top part. Judgment begins at 500?
Lordship, I'm referring to 576. There are two copies.
No, judgment begins at 500. And then
507.
507 is
Actually,
there.
there are two copies of the judgment in the same paper book.
Very well.
So the charges part is at paragraph 6 of the judgment, page 502.
Lordship.
At 502.
Yes,
It's very clear, the last sentence.
34 is not there. ma'am.
34 is there. Are
Charge was framed by my predecessor on so and so against the accused under section
50?
502, my lord.
paragraph 6.
Yes, 502.
Yes, my lord. Paragraph 6.
Paragraph 3.
That is the charge sheet being filed, my lord.
That was the charge sheet which was filed, my lord. Charge sheet was filed with 34, but subsequently the charges were framed and 34 was not a part of the charges framed.
No.
My lord, paragraph
Please come to
Yes, my lord. Paragraph 6.
paragraph 6.
Charge was framed by my predecessor on 11 August 2006 against.
Yes, we'll accept that. The 34 was not undone. The two of them were there. He pronounced that we'll read 34 into that and we'll give an explanation also. The moment he says you and together, that is 34. And the others were given read out because the others carried sentences. 34 does not have a sentence.
But formally, my lord, whether charge is required to be framed under 34 or not.
Charge sheet was given, which included that, and this was, we'll read that into it. Yes. Today's 27th. Day after tomorrow. Maybe at 2 p.m. day after tomorrow.
No. Lord, I may be permitted to appear virtually day after tomorrow.
You need not be there also.
No, my lord. I will definitely appear.
Thank you.